Welcome to our detailed exploration of the 2023 IT Rules Amendment case, a legal saga that delves into the intricate interplay between technology, free speech, and government regulation. Our narrative begins against the backdrop of the digital revolution, where the advent of social media platforms has transformed the landscape of communication and information dissemination. Hello, I'm your host Shambhavi and you're watching LiveLaw. In 2021, amidst growing concerns about the spread of fake news and misinformation online, the Indian government introduced amendments to the information technology rules. These amendments aim to empower the government to establish a fact-check unit to combat the proliferation of false information on social media platforms. At the heart of the matter lies Rule 3 of the Information Technology Rules 2021, granting the government sweeping powers to identify and flag content deemed fake, false, or misleading. This provision sparked intense debate over its potential impact on freedom of expression and government censorship. Before going any further, let's know a little more about the fact-check unit. Union government claims that the fact-check unit verifies claims about government policies, regulations, announcements, and measures. Through an established, rigorous fast-checking procedure, the PIB fact-check unit helps in dispelling myths, rumors, and false claims, and provides accurate and reliable information to the public. The PIB fact-check unit will be headed by a senior DG or ADG level officer of the Indian Information Service. The day-to-day operations of the unit would be handled by IIS officers at various levels. The unit reports to the Principal Director General PIB, who functions as the principal spokesperson of the Government of India. Let's understand the working mechanism of FCU. The Union government claims that the individuals can send requests over WhatsApp, email, or a web portal to the FCU. Each such request received is considered as a query. Queries are segregated by the unit based on their relevance to matters pertaining to Government of India. Only queries pertaining to Government of India are considered and taken up as actionable queries, while others are deemed not relevant for action. The information in question is checked rigorously through multiple layers of cross-checking through government open source information, use of technological tools, and verification from the concerned Government of India organization. Should the unit come across a piece of information that the unit ascertains must be busted publicly for the larger benefit of the people of India, after investigation and verification from official and authoritative sources, it publishes a fact check on its social media platforms. Often, a single fact check can be a result of multiple queries. As the amendments face legal challenges, advocates representing petitioners, including renowned comedian Kunal Kamra, rigorously argued against their implementation. The petitioners, represented by senior advocate Mr. Navroz Sirwai, contended that the amendment granted excessive power to the government and posed a threat to freedom of speech and expression guaranteed under the Indian Constitution. They argued that the vague language used in the amendment, particularly the terms fake, false, or misleading, lacked clarity and could be arbitrarily interpreted by the government. This ambiguity over the terms, they argued, could lead to censorship and stifling of dissenting voices on digital platforms. Furthermore, they pointed out that the amendment did not provide a clear mechanism for identifying and addressing misinformation, thereby leaving room for misuse and abuse of power by the authorities. Additionally, the petitioners highlighted that existing laws, such as the blocking rules of 2009 and the Press Information Bureau, were sufficient to address instances of misinformation without the need for the amendment. They argued that the government's proposal to establish the fact-check unit as per the amendment was unnecessary and could lead to overreach by the government in regulating online content. They also emphasized the importance of public opinion and democratic principles in the shaping policies related to online content regulation. On the other hand, the respondents, that is the Union of India, represented by the Solicitor General, Mr. Tushar Mehta, argued that the amendment was a necessary step to combat the spread of misinformation and protect public interest. SG contended that the amendment provided a balanced approach to addressing the challenges posed by misinformation on digital platforms without unduly restricting freedom of speech. To buttress his arguments, SG emphasized that the amendment aimed to hold intermediaries accountable for the dissemination of false or misleading information and did not intend to curb legitimate speech or political discourse. The Solicitor General highlighted the provisions of the Information Technology Act 2000, particularly sections 69A and 79, which empower the government to take action against online content that poses a threat to public order, sovereignty, and national security. They argued that the amendment was in line with the objectives of the Act and provided a legal framework for regulating online content responsibly. Furthermore, the respondents asserted that the amendment did not infringe on the rights of individuals, but rather aimed to protect them from the harmful effects of misinformation. They emphasized the importance of maintaining public trust and confidence in digital platforms by ensuring that they are free from false or misleading information. The case was brought before the Bombay High Court, where Justices Gautam Patel and Neelam Gokhale presided. However, faced with conflicting opinions, the court sought clarity through a third opinion from Justice A.S. Chandorkar. Justice Patel's verdict underscored concerns about potential government overreach, condemning the amendments as a form of censorship that infringed upon fundamental free speech rights. Justice Patel said he would strike down the rule as it was a form of censorship, as the amendment violated the right to free speech under Article 19 of the Constitution. What troubles me about the impugned 2023 amendment, and for which I find no plausible defense, is this. The 2023 amendment is not just too close to, but actually takes the form of censorship of user content. The court further stated that the amendment made the government the final decision maker of not just what was false or misleading, but also of the right to have an opposing point of view. By shifting responsibility for user content to the vulnerable segment, which is the intermediary, the amendment of 2023 effectively allows the government, through its fact-check unit, to be the final arbiter, not just of what is or is fake, false or misleading, but more importantly, of the right to place an opposing point of view. On the other hand, Justice Gokhale upheld the amendments, emphasizing their necessity in combating misinformation while safeguarding genuine expressions of opinion. Justice Gokhale rejected the argument that the impugned rule, by encompassing critical opinions, satire, parody, and criticism, renders it unconstitutional. She underscored that the rule specifically addresses content that is fake, false, or misleading, and not genuine opinions or expressions. She emphasized that the terms fake, false, or misleading are to be understood in their ordinary sense. Justice Gokhale stated that Section 79 of the IT Act was read down in the Shreya Singhal case to only cover restrictions under Article 19 of the Constitution, meaning intermediaries lose safe harbor or protection from hosting third-party content only if the offensive information violates the reasonable restrictions in Article 19. After meticulous examination and deliberation, Justice Chandorkar delivered his opinion that while valid concerns regarding the constitutionality of the amendments existed, the balance of convenience ultimately favored the Union government's position. The Supreme Court last month stayed the Union's notification of the fact-check unit under the Information Technology Amendment Rules 2023. The stay shall operate till the Bombay High Court finally decides the challenges to the IT Rules Amendment 2023. The Supreme Court set aside the March 11 order of the Bombay High Court for an interim stay on 2023 amendment to the IT Rules 2021 and restrained the government from notifying its fact-check unit, and refused to stay the implementation of the rules and the consequential order allowing the centre to notify the fact-check unit. As we conclude our exploration of the 2023 IT Rules Amendment case, it serves as a poignant reminder of the complex challenges inherent in regulating digital spaces. This case highlights the ongoing struggle to strike a delicate balance between preserving democratic values and navigating the complexities of the digital age. If you'd like to know more about this case, please visit our website www.livelaw.in. You can also search the case title on LiveLaw to get the full story. We have added the link to the same in the description box below. Make sure to let us know what are your thoughts on the fact-check unit in the comment section below, and also suggest some topics that you would like us to cover in our next video. Stay ahead with quick legal updates only on LiveLaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.